Welcome, everybody. Thank you for attending our webinar today about the EB2-NIW. We see we have more than 100 people registered, 100 people already inside, 400, almost 400 people registered. We're going to wait a few minutes before we get started officially, so we can wait for more people to jump in, but we'll be starting in about 2 minutes. Today, the webinar is going to be about the EB2-NIW. EB2-NIW as a strong option for eligible applicants. Let me see, we have people from different parts of the US. Let's see. A lot of familiar names. Thank you, everybody, for joining. We have Abraham Benhamo, Sandra Calderaro, Isabel Castillo. Hello, everybody. Some people from our team. Wow, we have people that are attending from all parts of the US. Welcome, everyone. Thank you for attending our webinar today about the EB2-NIW. For those who are just jumping in, we're going to be starting in 1 minute. We have 155 people right now in our room. We have almost 400 registered. I think we're all set. Let's do this. Welcome, everyone. Thank you for attending our webinar today about the EB2-NIW. During the pandemic, we started doing webinars among our partners in Canada that became very successful as a way of sharing knowledge between them regarding different immigration programs. Many of the shared insights are coming from experience beyond what can be found in legal books and are a great benefit to immigration professionals to share and grow together. We're excited to share that this is our first webinar on the US side, and we have about 400 people registered. This time we've selected a very popular topic, the EB2-NIW, and we have a wonderful guest speaker that I'm going to be introducing shortly. I would like to first introduce myself. My name is Marianella Manzur. I'm the Director of Sales and Marketing here at Joorney Global. I'm an immigrant myself, originally from Colombia, and proud to be part of Joorney. I believe Joorney doesn't need an introduction. Today, we're not here to talk about us, because most of you have already worked with us and know our values by heart. Today, we have some members of the team, including Paul Munson, our Chief Commercial Officer. Hey, Paul, how's it going? We have Eliana Jimenez. Let me show Eli on screen. Eli is our Vice President of Sales for Latin America. And our wonderful team members from our marketing team, Dragana and Rachel. Thanks for everything you do to make this possible, girls. A little disclaimer, just a small reminder that this is a webinar intended to be from an immigration lawyer to other lawyers and immigration professionals. For those of you who are interested in the EB2-NIW as applicants and are here with us today, feel free to listen in and reach out to our guest speaker today for any additional questions. Please consider that there's going to be technical vocabulary in some parts of the webinar, so just to keep that in mind. Also, please note that Joorney does not provide any legal advice. We always leave that part of the process to our wonderful partners. So we're going to be having our guests talk about the EB2-NIW, and at the end, we're going to leave some room for Q&A. We've already received a ton of questions. When people registered, they included a few questions there. So we're going to answer a few of those. And please feel free to add any more questions that come up on the tab on your right-hand side. Okay. Now, I have the honor of introducing our amazing guest. With 20 years of experience in immigration law, Carmen Arce is board-certified immigration and nationality law expert in the US. Since 2001, she has been practicing law, and since 2011, she has been representing immigration applicants from all over the world as the owner of her own firm, Arce Immigration Law. She has vast experience in immigration, a person that lives her practice. Carmen is a spokesperson for immigration issues in the US and worldwide. Carmen has been working with Joorney for more than 8 years now. She is both our partner and our friend. Welcome, Carmen. We are very grateful to have you.
Thank you, Eliana. It's always, sorry, Marianella. I'm thinking of Eliana. It's always a pleasure to be with all of you. And, you know, the history with Joorney does go back. I remember first meeting Paul at a conference many years ago. And what really took place after that was that I realized that I needed to be more involved with my clients on the business plan side, because I was getting business plans for different types of cases where the English was not up to par, where I was spending hours and hours correcting simple, minor things that I shouldn't have been spending my time on. And so Joorney was the first business plan provider that I ever worked with, and we've been working together since then. So it's a pleasure to be here, and I love speaking and educating and learning from other attorneys. And EB2 is, you know, one of our fortes. It's one of the case types that our firm specializes in, and we have literally filed thousands of EB2 national interest waivers.
Wonderful, Carmen. Thank you so much. We're very grateful to have you here, and we have so many questions and so many topics to talk about that let's jump right in.
Yes.
Great. Let me just put up the questions so people can see what we're going to discuss. And we're going to be having Carmen answer a few of the questions. So let's start talking about the EB2-NIW. Let's have a brief overview of the visa, who is eligible, basics parts of the EB2-NIW.
Okay, so when I lecture regarding any EB option, I try to explain that EB means you're dealing with an employment-based permanent residency application. Basically, it's an immigrant visa, and there are only 5 different types. So the wonderful thing about EB2 is that it's one of the few types where you can self-petition, which means if you do it as a national interest waiver, you do not need to have a job offer per se. But it's not for everybody, and I know we'll get into that more later. But there are wonderful benefits if you have a client that you feel is going to serve in an area of national interest to the U.S., you really should be learning, and you should be filing and representing clients on EB2 national interest waivers. So, you know, when I first did my first case, I had been attorney for several years. It was when I opened my own firm, and a Brazilian client came to me and said, you know, I think I qualify for EB2 national interest waiver. And I was like, I've never done one of those. Let me research it. And yeah, I do. I agree. You qualify. Let's do this. So what did I do? I went to Ira Kurzban's book, the Immigration Law Source book, and I read up on it, and I figured it out on my own. And so since that time, I've been trying to persuade other attorneys to really learn EB2. Then Danisar happened a few years after that point in 2016. And I think that really opened the door for several practitioners to really get started in learning and representing clients on EB2 national interest waivers.
Great, Carmen. Thank you for that. And again, covering some of the basics, what types of applicants would fit this visa type? And we're going to go into more complex topics afterwards.
I mean, there are all different case types that you can argue that would qualify. Again, you always want to start with Kurzban's Immigration Law Source book. If you go to the book and if you go to the section on EB2 national interest waivers, there are basically 11 case types that have precedent for qualifying. And in those case types, you'll see there are engineers, music is one of them, there are health professionals, entrepreneurs, business owners, and they do have those separated out. Information technology is there. So an easy way for a new attorney that hasn't worked on a lot of EB2s to think about it, think about STEM and think about STEM OPTs. So science, technology, engineering, and mathematics. If you have someone with a high level degree or a lot of experience in those areas, probably they're going to qualify. Not all, but many in those areas will qualify. And then sometimes you have to be creative and do a little bit of your own research, because sometimes you'll get a case that you've never heard of before. And you'll say, you know, I've never heard of what you're doing, but let me look into it and see if I think that this would serve the national interest of the U.S. because it's something so rare or unique. And so that's where we start. We try to start with the book. And then from the book, we try to look at what's going on right now worldwide. What are we hearing news about that there's a lack of? What are we hearing news about that there's any White House initiatives on? What are we listening to from Department of State, from news worldwide on this specific area? And if it's like logistics was a huge area during COVID, where you're hearing from world leaders, these problems with the logistics were causing major crisis worldwide. And what does that mean? That means that any logistics specialists have a really good opportunity there to file a national interest waiver.
Okay, perfect. So let's say the shortage topic also brings in opportunities for the EB2-NIW. And
yes.
Mm-hmm.
I was going to say, a shortage alone isn't enough. And that's, a lot of people will come and say, and it's not enough just to say, okay, there's a shortage. But you have to prove, yeah, that can be a starting point, and you have to go beyond that. You have to prove that what your client is specifically going to do is going to have impact, is going to be substantial merit, and your client's well positioned to fulfill their proposed endeavor, to go forward with it. So you always want to start with your client's background, their experience and their degrees. But then you have to ask the client, what do you plan to do in the US? And sometimes you'll have a client that says, yes, I have a PhD in economics, but actually I'm just going to surf. Well, that case isn't gonna work out. And so you want to be honest from the beginning with your client and set their expectations. And so if they have this specialty, this area of expertise, then they have to prove they're going to be working in that area.
Mm-hmm, mm-hmm. That's a very good point. And I'm going to jump to another question that we have further along. What supporting evidence would be the best to show that an applicant will significantly contribute to that national interest, Carmen?
Okay, this can be answered in so many different ways, because a lot of times I'll talk to a client on the phone, and I'm just thinking of a case that the client just messaged me. It got approved, EB2 national interest waiver. But when she first came to me, she's a dentist from Honduras. I was like, no, your case, I don't think you're ready yet. You need to first either validate your degree here so you can practice dentistry in the US, or you need to have some type of a job offer or already be working here in your area, because right now you're not a dentist. So it took her a couple of years. She did what she needed to do. She validated her degree so that she could actually work in the US as a dentist. Then we filed her EB2, which was just approved in a really relatively quick time. And she just messaged me 2 nights ago. But if I had taken the case, and I've seen a lot of attorneys do that, just based on her Honduran dental, practice and dental license, she's not really well positioned because she can't practice dentistry in the US. And so to answer that question about the evidence depends on where your client is at this moment. We always start with 3 very basic recommendations, which are, okay, let me see a copy of your resume, your degrees, and your transcripts. That's where we start. And then we go from there and really try to understand the background of our client in whatever country they were in. Then talk to our client about what they want and plan to do in the US, because there's several ways to prove their proposed endeavor. But what really you don't want to do is force a client into a situation by telling them, oh, you need to open a business. If your client has never been a business owner in the past, then opening a business for them, or them opening their business, won't necessarily be successful, because immigration oftentimes will come back and say, well, I don't believe you are well positioned to be successful in this proposed endeavor because you've never been a business owner before. So some applicants and some attorneys have a misconceived notion that every EB2 needs to be a business owner. That's not the case. So there's several ways to prove the proposed endeavor. Of course, if the client was a business owner and that is their proposed endeavor, then we want to prove a few things through the business, and we let them know that from the consultation step, that we're going to want a business plan, we're going to want a corporate website, we're going to want a commercial address for the business. Those are basic things that to set you up so at the time you file, you can already prove from the date I filed, I was well positioned.
Okay, wonderful, Carmen. Thank you for sharing that. Going back to a couple of the basic questions. What are the steps when an applicant wants to apply for an EB2-NIW? How long does the application process usually take?
Okay, well, first I want to focus on one thing you said. A lot of clients come in and do a consultation and they say from the beginning, I want to do an EB2. But our job as an attorney is to really evaluate the client's profile and let them know whether or not you think they have a chance of success on an EB2, national interest waiver as a self-petition or through a petitioner. So that I just want to focus that when a client comes to you as the attorney and says, I want to do an EB2, you don't just file an EB2 for them. You need to look at their background and see if they really qualify. And I feel like our job as attorneys is to look at the weaknesses of our clients and try to focus on those weaknesses before we file the case so that we're not at a disadvantage at the RFE stage. So I'm not sure if that really answered your question. If not, you can repeat it.
Yes, it did. But then going back a little bit to the steps, like what do you usually do? I mean, receive them, evaluate that this is the right visa for them, etc.
Gotcha.
And then the details on the application.
Okay, so when the client decides they want to hire us, then the first thing we do is we send them instructions and details and a list of information we need from them to work together to develop their case, to develop their business profile as well. So like I said, the 3 documents that we always require, I try to tell a client, those are your building blocks. From there, we have to evaluate the client's resume to see what other evidence we might need. Like, let's say our client on the resume states that, and this happens a lot, states they have a master's from Brazil, a master's degree. So then I ask them, can I have a copy of it? Well, I didn't actually finish the master's degree. So it can be difficult. So we always start with those 3 building blocks. Now, once we have that, then we focus on what's my client's plan in the US? What's their proposed endeavor going to be? If it's going to be opening their own company, we have a lot of homework and things we need to do before we can file the I-140 and prove we're well positioned at the time of filing, which is we're going to ask them to go ahead and establish their business, get the business plan. They need to have a website and they need to have the commercial address. Those are all very important steps before we file the case. Now, so we spend it takes us around really about 100 days to prepare a really good EB2-NIW. And at the end of that time period, we're filing the I-140, whether we file it consular or whether we file it stateside with an adjustment of status or stateside standalone. At that point, we're waiting for the government to come back with their answer. Now, as we all know, a lot of us got false hope regarding this premium processing for EB2s. It is there, but only after your applicant is already waiting a significant amount of time can you then upgrade to a premium processing petition. So in filing it normal, we're getting answers and responses anywhere from as fast as 4 months to as long as over 24 months. So I try to explain that to the client at the time of filing that this can take, anywhere from at least a year usually to well over 2 years even in some cases. And at that point, the government can come back and either approve, deny, NOID, or RFES.
Okay, and we'll talk about a little bit more about that later on. So aside from like the uncertainty of the timeline, what other challenges, Carmen, have you faced with these types of applications for EB2-NIW?
Well, I know that another question you're going to ask me is when the client files with one proposed endeavor and that changes during the course. Like I'll give you a lot of examples. During COVID, clients filed before the pandemic and they had planned to do A, but during the pandemic, everything changed. And by the time we get an RFE, they're doing Z. And so we have to go back and try to respond to the RFE and explain that as long as it's still within the client's area, it's common for their plans to change. And it's not necessarily going to result in a denial. But ideally, from the time you file, you stick with the same plan. You want to be consistent. The government wants you to be consistent. We as your attorneys want you to be consistent. So we really try to work with our clients to develop a secure plan that they're going to be happy with and that they're going to continue.
Okay, so that has been one of the biggest challenges as well. Yes. Certainly. And there's a question that we get asked a lot, and we face it a lot at Joorney, and we actually saw it from a lot of people who registered. What areas do you not recommend for an EB2-NIW? A lot of people are asked about pilots and about other different industries. You mentioned logistics, you mentioned dentists. What areas do you not recommend for an EB2-NIW?
That's a great question. I don't recommend just general business administration. So if I have a client that has and a lot of times a client will come to me and I'll say, hey, you seem to be interested in finance. Why not get an MBA, but in finance, in a specific area? So a general degree in business administration, we wouldn't file the EB2 national interest waiver unless that client also happens to be an entrepreneur with some success behind their background or under their belt. Attorneys, we don't usually do EB2s for attorneys, and there's a few reasons why. One reason is that in immigration, Kurzban's immigration law sourcebook, it specifically cites a case where immigration found or case law found that EB1A is not meant for attorneys. And so if you try to transfer that over into the EB2 national interest context, it's a bit of a risk. Have we represented some attorneys on EB2 national interest waivers? Yes, but when they have a specialty, for example, in international taxation, or they have an LLM, which is, a master's of law, in an area where we can argue, okay, that coupled with your law degree, we think we might have a valid case there for a national interest waiver. But for most attorneys or general business administration, managerial positions, those don't typically qualify, in my opinion, for an EB2 national interest waiver, and they're probably better suited for a labor certification.
Okay. And what about pilots, the pilot issue?
We do represent a lot of pilots, and we have for many, many years, and not just in EB2-NIWs, but in labor certifications and in EB1As as well. So right now there are several different crises going on within the aviation industry. So yes, we do represent pilots. We do win the great majority of our EB2 national interest waivers for pilots. That being said, pilots, just like lawyers, every pilot is different. They have different background, different experience, different level of expertise as a pilot. But yes, we do represent pilots, and we do EB2 national interest waivers for pilots.
Thank you for that clarification, Carmen. Another thing, as you know, we do a lot of business plans for E2s, L1s, EB5s. So there's a lot of different attorneys that previously considered the E2 for some of their applicants. And now we're seeing that the EB2-NIW has become an option for those people who were previously considering E2. What are your thoughts on that?
And recently I did a live in Spanish with a family who went from E2 to EB2. So they had done their E2 with a different attorney, and basically they had no options for permanent residence. Their other attorney, didn't have an option, didn't have a plan for them. And so they came to me through a few other clients who had done their EB2 national interest waivers with me. And I told them from the beginning, listen, this is a long shot. It's not an easy case. It had to be exceptional ability. So when you're looking at EB2 national interest waiver self-petition, you want to try to qualify your client as advanced degree if you can, because it's a little more objective. You can easily prove whether the client has a master's degree or a bachelor's degree plus the 5 years experience. Whereas if you're trying to prove exceptional ability, that's always more subjective. So this specific client didn't have a degree at all. All he had was entrepreneurial experience in a few different ventures he had done abroad and in the US, which was, of course, his E2. So what was his E2 in the US? It was a pizzeria. But before I took the case, I went and visited his pizzeria, and I ate his pizza. And not just his pizza, it's more than, he also has other Italian goods, and he is Italian. And he's like, listen, Carmen, when we first consulted on the phone, he was like, you have to understand, what I'm doing is different. What I'm doing is special. I'm like, okay, well, let me go there and visit, and I want to see how different and special this really is. And I'm like, you know what? I think we can, we have a case, and at the end of the day, it's your only option. Because why? He's a business owner. He can't do a labor certification. He didn't have an EB1C. He didn't have a company abroad anymore, so he couldn't do the EB1C. And he was out of time because his daughter was turning 21 in just a matter of months. So I'm like, listen, try the EB2 national interest waiver as an entrepreneur. Let's really go into your exceptional ability in business. And that's what we did, straight approval. So is every case going to be that easy? No. But that clients, if you look at their long road, they didn't have an easy road either. They did 2 different E2s before they got to the EB2 stage. And they had been told by many attorneys, there's no option for you. And so at the end of the day, I'm like, yes, technically you can apply. You're a business owner. It's one of the 11 precedent-setting cases for EB2. We'll have to do it based on exceptional ability, but what do you have to lose? So that's what we did, and we did win the case.
And in that case, I mean, that applicant in particular, they didn't have a lot of options. But what
Exactly.
about, I mean, if there's somebody who has an E2 and they want to eventually get a green card, would that be an easier route if they are eligible and fill the requirements?
I always say there's nothing easy when it comes to immigration. Even maintaining F1 status is not always easy. So I would say that it's a viable option. When you first do your analysis and your evaluation with a new client, you always want to explain, if they're a business owner, do they have an L option? Do they have an E2? Then explain how you can also go E2 to EB1C, or you can go E2 to EB2, or you can go E2 to labor certification through the spouse. So there are those options. I think the problem is that a lot of times you're not thinking of the long term, you're thinking only of getting the E2, the short term. So what we really try to do at the time our clients first consult with us is go ahead and find out, are they interested in a future permanent residency case? And if so, let them know what they need to do, regardless of whether it's the EB1C, the EB2, or the EB3, or the EB5, to get them set up to where they're going to be well positioned to have success on any of those case types in the future. So the first thing we look at when a client comes, do they have children? How old are the children? If they're getting close to 21, we need to have some type of a path to permanent residency in place.
Definitely. And what are the major advantages of applying for an EB2-NIW? Carmen, I remember that we spoke recently and you said that one of the reasons why EB2-NIWs were also being filed more was because the E2s had issues with the consulates abroad.
That's true. So for even right now, in Colombia, they're still not, giving appointments for E2s. And I think a lot of people during COVID, got frustrated, and they're like, you know what, I don't want to depend on having to get these interviews that are impossible to get to be able to travel. And so, I mean, we had issues with several of our clients that were either in both situations, and EB2s as well. You have to wait to get the advanced parole. So I don't necessarily think that EB2 is an alternative always to E2. I think it's smarter and safer if you have the luxury of being able to do an E2, start with the E2, because going from E2 to EB2 will set your client in a better position for probability to win, because they can use those 5 years usually that you have under the E2 to develop the business and to prove the importance of what they're doing here in the US. They can then, jump to the EB2 and still, have that E2 to fall back on if they need to. Yes, we all know E2 doesn't necessarily have dual intent, but you transfer over. You can keep the E2, file the EB2 standalone, wait to get that approval, and then either do your consular processing or your adjustment of status.
Okay, great. And in that sense, Carmen, is the EB2-NIW now having more approvals than any other EB option? What do you think?
I mean, to be honest with you, I think right now across the board, I mean, it's a great time to do labor certifications as well, and even EB1Cs and Ls. So I think that we are seeing a lot of approvals. Of course, you never get 100% approvals if you're filing a great, amount of cases. That's not always, the end of the road. A lot of times the client can refile or they can appeal the decision. And so you really want to look carefully when you get the RFE at what it is that the government is having a problem with, or what the issue is. And you really, really want to focus on getting some independent, objective evidence at the time that you are trying to respond back to an RFE or a NOID. And by that, what I mean is, we are now recommending 3 expert opinion letters, objective expert opinion letters, to prove whatever point it is you're trying to prove, whether it's national importance, whether it's substantial merit, well positioning. Get the objective, independent expert opinions.
And that's great that you mentioned the RFE NOID, because on our end as business plan writers, we get a lot of business plan requests after receiving that RFE. So I wanted to ask you, Carmen, because you've been mentioning it a few times. What is an RFE NOID, and are they very common on the EB2-NIW, and how do you usually respond to one?
They are really common. A new trend we started seeing just recently this year is that in some cases you'll get a request for evidence, and usually a lot of the cases that are being adjudicated now, they were filed 3 years ago. So we're now getting a lot of adjudications on cases filed in 2019, and COVID happened, and the officer usually is coming back to say, okay, you said your client was going to do A, B, and C. Are they doing that? Have they created any jobs? Are they selling their product? Are they doing what they said they were going to do? So at that point, if the client was a business owner from the beginning, and they never filed a business plan, they need to do it, and immigration's asking for that. And a lot of times they need to update a business plan because it's outdated and things have changed. So when you get the request for evidence, the first thing, or the NOID, the first thing you want to do is read through it carefully. I mean, a lot of it is just boilerplate, but you want to respond to each and every doubt, question, issue that the officer raises. Now, back to the trend we started seeing recently. On a lot of EB2 cases, we would get a request for evidence, respond to every one of those points, and then turn around and get a notice of intent to deny on something totally different. But that's not usually, in my opinion, when I get that, I actually have hope. I'm like, you know what? This officer could have just denied it. He didn't deny it. He issued a NOID. So now we got to respond to that. And really and truly, when that happens, the majority of what I've seen happen after that is it gets approved. And so it's not at the end of the day. We have a lot of clients that come to us and hire us at the RFE stage, which is not what we really want. And so at that point, we basically a lot of times have to do the case completely over from scratch. And as I spoke with you earlier, we're working on a case like that right now with Joorney. We were having to revamp everything and redo everything. And I was just at a loss of why the attorney would have put the client, their proposed endeavor, as general manager. That's not an area for an EB2 national interest waiver. It's very, I mean, the name alone, I'm a general manager. No, you want to be very, very focused and very specific in what your client's talent is. And this client specifically has like post-grad degrees and undergrad degrees in foreign trade, and should have always been presented as a foreign trade logistics specialist, because that's what she does. If you looked at her resume, that's all it is. So why the attorney put her as a general manager, I have no idea. But it cripples us at the RFE stage. So that just goes to really, really having to sit down and plan your proposed endeavor from the beginning with the attorney, and think of all of the future, what can happen, and really try to present in the business plan something you're going to be able to fulfill at the RFE NOID stage.
Great. So you were mentioning the importance of having a business plan for the application, Carmen, and you were also talking about the fact that some people may have to or will create a business, but some won't. How does the business plan fall into all of this?
So a lot of times someone will come to me and say, oh, I need a business plan for my EB2. I'm like, well, let's see, what is your proposed endeavor? If your proposed endeavor is to work as in a multinational company as a drilling engineer, for example, then you don't need a business plan. You're not opening your own company. You're going to be working for Shell. So in that case, a lot of times I even have to argue with the clients, and I'm like, no, trust me, you don't. But that's where this new RFE trend has come in, where they ask for the client's personal plan, and they want it in the client's words. And so we call it like a personal statement a lot of times. And so when a client is trying to navigate the whole process of whether they're going to hire or whether they want to do an EB2, you really have to focus on look at their resume. If they've never been a business owner, they're probably not going to be a startup business owner in the US from scratch. A lot of times our clients work currently with multinationals abroad. So their proposed endeavor may be to transfer and work in that position or in a similar position in the US. In that case, they don't need a business plan. So, you know, it's a case-by-case analysis, depending on what the client plans to do in the U.S.
Okay, perfect. So we have a lot of attorneys here with us today as attendees. What would be the 3 main recommendations you would give to an attorney when they're working with an EB2-NIW overall?
I would have them first dissect the client's resume. Everything starts from the client's resume. I would also make sure they know what prior cases, what prior immigration visas, what has the client done in the past? because inconsistencies can ruin a really good case. And a lot of times, unfortunately, your client may not have access to, prior filings, or not even know what was submitted, and that can cripple you, because you have to let the client know. Listen, at the RFE stage or later on down the road, the officer may very well come back and ask about inconsistencies of something you may have represented when you filed for a B2 visa on your JS-160, or it may have been, completely presented differently at the L1A stage or the E2 stage. And so it's really important to know your client's past before you can prepare for a really good future for your client. And when I say dissect the resume, I'll give you an example. We had a client come to us. She's a PhD from the US in business. And she had her work experience listed as customer service representative. I'm like, no, you are not a customer service representative. And I showed her, I went through like some job descriptions and own it. I'm like, I'm sorry that you're considering yourself or that you're calling yourself that, but that's really not what you're doing. You're really a business analyst. And she's like, oh yeah, you're right. But so we really, really look carefully at the client's resume and try to pair that, and always look back at their degrees. And sometimes on the degree side, if your client has the foreign degrees, you want to make sure and look carefully at the equivalency evaluation. There's been many cases where we had to disagree with the evaluation services and say, listen, I've seen the client's degree. It specifically in whatever language states this specialty or this focus, and I want that listed on the evaluation because it can make a big difference. And engineering is a great example. There are so many different types of engineers. And so when you look at your client's resume and their degree, and a lot of times I'll have one of our associate attorneys, I'll say, bring me the copy of the degree. I want to see it. I want to actually look at it. And so then at that point, we can see, okay, if there's a distinction or an inconsistency, like recently, our client's resume said one thing, the degree said something different. And so that can cause a complication or, an inconsistency, which you don't want. So I would say my biggest recommendations from the beginning would be dissect carefully your client's resume, be involved with your client's equivalency evaluation, and be very involved with what it is your client plans to do in the U.S.
Mm-hmm. Okay. Thank you, Carmen. So at Joorney, while writing the business plans, we see a lot of trends as soon as they start happening. So with the EB2-NIW, we started doing business plans back in 2017. We were doing a few. And right now, I mean, we were maybe doing 20 before, and right now we're doing hundreds of business plans. And these are usually for professionals that are coming from different parts of the world. So do you see a trend of specific countries that are taking advantage of the EB2-NIW more than others?
I mean, I think that, and Eliana from your team will agree, it really, within the Brazilian community back in, that's where I, started with my first EB2. And it was common knowledge, and it was really, really marketed to the Brazilian community. And then through word of mouth, I feel like, at least with my practice, it spread throughout South America. So then it went to the Venezuelan community. And I spoke with attorneys several years ago. This was, I think, 18. And I told them in Miami at a Catholic Charities, I think, foundation, I said, if you don't know EB2, you need to learn it, and you need to be, well-versed and be able to advise your clients on it. Because if you don't, there are several other paralegals, attorneys, and non-attorneys out there doing this, and you need to understand and to be able to advise your clients on it and not be scared of it. So, and especially for Venezuelans at that point in time, this was before TPS, way before, it was a good option. There are a lot of Venezuelan high-level professionals that were here in the U.S. and they thought their only option was asylum, and that just wasn't the case. And so I'm now seeing a trend with Colombia. I think that anytime a country starts having any type of political turmoil, then a lot of high-level professionals are looking for alternatives and looking for options in other parts of the world. And so right now we're getting a lot of interest out of Colombia.
Wonderful. On our end, we've seen a lot of Brazilians, a lot of Colombians, as you say, and also a lot of people coming from Russia, actually. That's also an option. And probably because the L1 is not an option for them, maybe they also look for options in the NIW.
Yeah, I mean, for sure, for clients that come from countries where they don't have an E2 treaty, a lot of times it may be their only option in some cases. And so every country has different, possibilities. Like a Canadian or a Mexican, we have TN, we have E2, we have EB2. And so, it's a case by case thing, but definitely we're seeing a trend. Brazilians have always been, in my opinion, at least since Janisar, very knowledgeable regarding EB2s, and they definitely, the word is out. They know about them. They come to you a lot of times with very specific questions. They've already done their research. I feel like Venezuelans and Colombians are catching up. And worldwide, we are getting, you do one case for one person out of, like, we have a client from Ghana, and from that one client, then you might get 10 other clients because he knows 10 other professionals from Ghana, and they're all going to come to you because they never heard of this before.
Great. And I'm gonna turn it now to Ellie, our VP of Latin America. Ellie, so about what we were talking before with Carmen regarding that there's two types of business plans depending on the focus of the EB2-NIW. You have had the experience and you know these because you speak to so many clients on a permanent basis. Can you tell us a little bit about the difference between the personal plan or professional plan and the regular company business plan?
Yes, of course. Well, thank you again for the opportunity to share this. Actually, we do have a lot of this kind of difficulty for people to understand between professional plan and business plan. So the professional plan basic, it's for that kind of person, as Carmen explained, that it doesn't have like a background on business, and it's the STEM, it's very common, or pilot sometimes, where we are going to explain on the project about that person as an individual contributor to the United States. So we are going to explain on a better way, backing up with the information from government, from sources, that this person is important and will impact the economy as a person. On the other side, the business plan, it is a complex document. It is for that person that has the background, the entrepreneurial background, and we are going to describe their proposed endeavor as what business they will develop here in the United States, how this business will impact the economy by generating jobs, sharing knowledge, and usually it's a document that will be developed on a very positive scenario that the immigration office can have a better picture. We do projections for 5 years, not only on their earnings, but also on their hiring plan, on the potential of that business. So basically that's two documents, and the attorney will decide which one will fit to that person as their background or as their resume.
Thank you, Ellie. And you've been having a lot of volume these days, a lot of workload from Brazil with the EB2-NIW, right?
We do. Unfortunately, a lot of people trying to do on their own. So, and I do advise, if you are listening, to please, look for an attorney, speak with Carmen. You need to have someone backing you up, and not only, it's not that easy, but so we do have a lot of people.
Definitely. Thank you, Ellie. Thank you very much. Carmen, you were going to say something?
Yeah, I actually just listened to Eliana, and we've worked together for many years on many cases. And, I had an EB2 client come to me at the RFE stage. She was an attorney, and she was actually working at that time for a very well-known bank. And the way that EB2 had been presented, it was just a mess. It was all over the place. And she could see that as well. She was a very difficult client. And to rescue the case at the RFE stage, I told her it's almost impossible. We lost. And then we appealed. Meanwhile, I'm like, let's focus on your husband. He's a really successful entrepreneur. And we did his EB2 national interest waiver. We got the RFE, and he had submitted a business plan at the time with Joorney. And we updated that because then COVID had happened. We updated that at the RFE stage and said, this is what's going on at the moment. And we also did something similar to a personal plan, but it was his personal statement. And, I worked with the case very closely with him, and I'm like, it's really important for this officer to understand who you are, your background, and what's the heart of the case. Like, what makes you tick? Why'd you get involved? And I think that can make all the difference sometimes. Another case that we had, which was an EB2 for an engineer from Syria, we got a really hard, we got annoyed, directly annoyed. And, she was livid, and she wanted to, she didn't want to hire us. She wanted to fire us. And I'm like, listen, just because you got annoyed, it doesn't mean we did an excellent job. We did. Here's the proof. We responded to the annoyed, but in the annoyed response, I made her tell her entire story and really open up her heart to the officer and say, this is everything I've been through, leaving Syria, going to Europe, then going to Canada, then coming to the US. And I really believe that's what made the difference, because everything else she already had. She worked with high level, very well-known, high-tech companies all over the world, great engineering background, and we got a straight annoyed. And so, I would just say that it's not the end of the day, and that you can still, as long as you, fight, you can still win after annoyed or an RFE and annoyed.
Wonderful. A lot of hope for people who are applying and maybe see no hope in other visas and find the opportunity with the EB2-NIW, definitely, right?
Yeah, and I think that the personal profile or the professional plan, I think that immigration officers, there is this trend, they are asking for it, and they really want, a lot of times they'll say, I want this in the applicant's word. And so you really need to work with your clients and closely and with Joorney and doing that and say, this is, and I spoke to Paul the other day regarding a different RFE we had, and he was like, our associate attorney did a great job of emailing Joorney right away and saying, this is where we are, this is when the RFEs do, this is what the officer's asking for, this is what the client does. And with plenty of time to give you guys to help us to respond to that RFE.
Mm-hmm. Thank you, Carmen. So this topic about the EB2-NIW has been very, very successful. We actually have around 40 questions that we received before, and we have like 70 questions that we receive right now on the chat. So I'm going to try to pick and choose the ones that we haven't addressed yet, and or maybe recap on some that we already did. So if it's okay with you, Carmen, I can start with those Q&As now?
Yes.
Wonderful. Okay, let me see. So we have from Gabrielle Jack, what are the NIW arguments for E2 to NIW?
There's not an argument for going from E2 to NIW. What there's an argument for is your specific client's proposed endeavor. So you can't possibly say this is the argument for E2 to EB2 at NIW. No. It depends on what your client's E2 is. Now, and this is where an E2 can handicap a client. Let's say the client is a chemical engineer, and they could have done an EB2 from the beginning, but they did an E2, and the E2 is a pet groom shop. How are you going to now go back and argue that your chemical engineer is using his pet grooming shop to somehow fulfill something related to his engineering degree? That would be really difficult. So what I'm saying is that I can't give you advice on that. But you need to look at your client's resume and look at what they're doing. And if their E2 company has nothing to do with what their background is, what their degree is, it might not be a good fit.
Mm-hmm. Okay, perfect. We have another one. Do you need a job offer to self-petition for an EB2-NIW? And you did mention it, but we can recap on it.
No, that's exactly what the waiver part is. The waiver is to waive the normal rule of having to have a job offer and do a labor certification. So no, you do not need a job offer at all to do an EB2-NIW.
Okay. How can a non-STEM graduate like linguistics fit their endeavor into areas of national importance?
So personally, I would start doing the research on linguistics. And speaking of that, I will say that we represent a lot of teachers. I was a teacher in my former life, and I personally really believe in the national interest in maintaining and recruiting really qualified teachers. And so we recently did a teacher case for someone with a specialty in special needs children, special needs students. And I remember that I got a little bit, well, I review almost every single case that comes out of our office. So our associate attorney had filed and prepared the case. And I'm like, let's just do some creative research. Just Google some things about, and I right away found a lot of research on how that specific community, special needs children during COVID suffered more than a lot of the other non-special needs children, and the real importance behind it. You want to always look at White House initiatives. So just because linguistics isn't necessarily listed, then you got to do your independent research and see, okay, well, linguistics is kind of general. What specifically does this client do? I mean, which languages does the client speak? Is the client working? Is she working in academia? Is she a professor? We represent a lot of professors. So I think you have to dig in a little bit more, but I do think that you can make a case out of that most likely.
Okay. This is something that we touched on before, but it seems to be very important because we got it from a few registered participants. Is a shortage of workers in the field a factor for NIW?
Definitely it's a factor, but like I said, that's a starting point. Then you got to do your research. So we can use teachers as an example. We know that there's a current crisis and there's a shortage of teachers. Do the research. Look at the state where that specific teacher or that specific person is going to work. We recently represented a client that's based out of Hawaii. Little did I know, Hawaii has one of the highest percentages of small businesses that fail. And that client is a business development specialist with a very high level degree. And so, before you even agree sometimes to take the EB2, you have to be able to feel confident that you can argue this. For you to argue it, you need to start looking at research, and you always want to pay attention to the news. Listen to NPR, see what's going on. I mean, I was listening to NPR the other day, and there was this story, and it was like the Secretary of Transportation, and he was calling out all the major airlines and saying, this is a disgrace. There are not enough aviation industry workers, including pilots, including a lot of other areas within aviation, and that it's becoming a national crisis. And so that's important. It's not just a shortage. It's a shortage that's going to the level of becoming a crisis. And then go and prove or look at the research of the impact of it. And that's when having a good business plan or a professional plan can definitely come in handy, because you want to have those studies.
Great. Let's see another question we have. This is a little bit more technical, which would be, what is the recommended approach to the third prong of the NIW? What type of supporting documents should you submit for each of the prongs?
Okay, so, well, every single case is different. So when you say third prong, are you talking about well-positioned for your proposed endeavor?
We would need to go back and ask the person who asked it. That would be Alan Ladd from Visas to America. Yes, I mean, it's not in the chat. It was one of the ones that were registered, so maybe we'll hear back from him in a bit. Can we talk about what type of supporting documents do you submit for each of the prongs?
And it's different for every single client, and so we don't have like, no, it's just, so if we're first of all, you want to start with the building blocks, like I said. Then if you're we don't have a specific, database for what we submit every time that we're working with an engineer or anyone, or a pilot, for example. Every case is different, and the research and the studies, they evolve. So yeah, we have some, and a lot of times we'll have our own Arce Immigration database saying, okay, this is what we've submitted successfully with pilot cases. What else has happened since then? What are the current trends? Is it a female pilot? Can we submit statistics on that? And so, I'm sure that other firms operate differently, and they may have already this is what we submit every time. We don't do that. We do it case by case basis. And so we don't have a specific magical formula for evidence on any specific case type. Okay.
Thank you for that, Carmen. I have a few questions regarding the conversion to EB2-NIW. So one person asked about the H-1B to EB2-NIW, and another one about an F-1 OPT to the EB2-NIW.
Yes, we've done both of those. One of our early cases was an OPT who didn't get the H-1B, actually. And she was working for Lynn University, and she was working here in Florida, and she was a music master's. And I'm like, well, music is in the book. Let's try it. And so we did, and it was a straight approval. So yes, you can definitely transition from OPT. And when you talk to those clients, like when that are in the master's program, timing is everything. So being in the master's program is not enough. They need to complete the master's program. Then they should ideally be working under their OPT when you file for the EB2-NIW. Now, and then going from H-1B to EB2-NIW. The problem you might come across in both of them is proving whether or not the client deserves the balancing on why they're not able to do a labor certification. So when you have a business owner, that makes it easier on that specific argument, saying, well, a business owner is not entitled to petition for himself on a labor certification. But when our clients are gainfully employed under an H-1B, for example, or OPT, you need to be sure that the client has already talked to their HR department about a labor certification, because you can win everything else and fail simply on the balancing on, well, why can't you do a labor certification?
Mm-hmm. Mm-hmm. Okay. I'm going to go back to this topic because it's very popular among the questions. So NIW for pilots, you were mentioning that you have done it. When would you say yes, and when would you say no to an EB2-NIW for pilots?
Well, definitely say yes when the pilot has a lot of experience. They have FAA certification, and a lot of ours have degrees. So anytime they have a degree, it's even better because, well, it depends on what the degree is. But a lot of our clients that are pilots have U.S. degrees in aviation security, something like that. They have foreign degrees, sometimes in military sciences with a specialty in aviation. And so the worst cases, in my opinion, for pilots are fresh new pilots that have just gotten their licensure, don't have a lot of experience. That's a harder case to win. We had a father-son, both Venezuelan pilots. The father, I think the difference was the father had several decades of experience, and his case was approved. The son was fresh out of flight school. They were desperate Venezuelans before TPS was around, and that the son's case got denied after an RFE, and we lost on one point. We had to do exceptional ability, and the officer didn't agree that being in the FAA counted as a membership, and so we strengthened the case, refiled, and hope to win on the refile.
Excellent. And I think this is a very good point, because a lot of people talk about are pilots eligible for the EB2-NIW as something that's very generic, but it's actually going back to what you were saying. It needs to be customized. It is per person specifically. Yeah. So that's good to have that clarified. We have a question from Andrea Bowers. How do you approach denials? Is it a practice in your firm to do reapplication, and what's the strategy? Do you just submit a new I-140 with RFP response, or submit a new I-140 and I-485?
Well, first, you really want to read carefully, of course, the denial. Denials are not fun for anybody, but there are several options usually of how to proceed. So we bring a client in usually, and it's usually going to be a meeting with me and with the associate attorney that worked on the case as well. I'll give an example of a Venezuelan. She had like an advanced degree in education. And when her EB2-NIW was denied, there were mistakes in the decision. Mistakes regarding, at one point it mentioned the client was from Brazil. At one point it mentioned she had a different degree than what she had. And so I told the client, this was also before TPS, the client's son had already turned 21. So I was like, listen, we really need to appeal this. The chances of winning are very slim, but there are mistakes in the record, and I think we can use that to our advantage. We did, but I said that's not all we're going to do. We need to have a plan B as well, and we had a couple of other options, but we appealed it, and we went on the appeal because of those errors in the decision. And so you want to look at your decision carefully, and you want to be upfront and honest with the client. The chances of winning on the appeal are if it's for a subjective discretionary matter, are really, really difficult. Now, I will say, and this is one of the reasons why we now recommend getting the 3 independent expert opinions at the RFE stage, because if they only deny on national importance and you have those 3 PhD expert opinions explaining why what your client's doing is nationally important, then I think you might have a pretty good chance on the appeal. That being said, sometimes we do look at it and we say, you know what, I think in this situation, let's think about a refile. What's going on with your spouse? Or is your spouse maybe employed and should be looking at a labor certification through your spouse? So I think it has to be case by case. I would definitely say, you know, you don't give up. We had a telecommunications engineer it was really funny, and I've really enjoyed working with him. We lost the first case. He was from Brazil. And he had a really wonderful resume, great background. He couldn't believe it. It was a real, you know, shot to his ego, and he talks about it. On the refile, he's the same person, working for the same company, same background. We got an RFE, and the only difference was, again, the 3 expert opinions. And he says, Carmen, I think that made all the difference. I think the officer had a really hard time understanding what it is exactly I do, even though we as attorneys tried to portray that as best as we could. But the independent, objective expert opinion letters really helped us at the RFE stage, and then we went on the refile.
Okay. Wonderful. We have our answer about the third prong. Let me check it real quick. So third prong relates to being better for the U.S. to waive the labor certification process instead of asking the applicant to pass through it. So the question would be, what would be the supporting documents for that third prong?
So then and that came up just after he said that. And I was like, I don't know if he means what position at that point or if he means the labor certification. So at the labor certification, balancing whether or not, you know, why we should deserve this discretionary waiver of that requirement. Again, if the client is a business owner, then you go to the code and you say, no, they're not allowed to self-petition. So right there, you should win that argument if your client is a business owner. If not, and if the client is employed, then from the very beginning, you should have found out, is the employer willing to do a labor certification? And a lot of times when we lose, and that's the only point we lose on, and by that point, if the client is employed, then you do the labor certification. So let's go to an engineer who is employed by Chevron and who isn't an owner in the company, obviously. You can go to the STEM arguments and you can say, listen, immigration and the U.S. government has already, you know, set aside this special requirements for anyone in engineering because of the lack of U.S. engineers. There's also a really good study. I want to say it was done by, I can't remember the agency name right now. And that study basically proves that engineers are not displacing U.S. workers, that U.S. workers are completely employed. Therefore, doing a labor certification is illogical because there are no unemployed U.S. workers to fill that position. Another thing, we always ask the employer if at that point they're employed. A lot of times when we file our initial filing, the client isn't employed yet. The client doesn't have an EAD. So it depends on what stage and regarding the evidence you can submit. But if it's the RFE stage, the client is employed. We ask, is your employer currently seeking other drilling engineers? Bring me that recruitment. Let's get a letter from your employer saying, hey, we're still looking for other employees. This applicant is not displacing the job of a U.S. worker. Therefore, it's illogical for us to have to do a labor certification. We're actively recruiting and hiring for the same position. So that would be the evidence I would submit when the client is employed with an employer, and it's a timing issue where they're like, why we shouldn't have to go through this because there are no unemployed U.S. workers for this position.
Okay. I have a question from Andre Plaskin and Flavio Busato, and it's similar. How can we define substantial merit in plain English? What does the applicant need to prove to satisfy this requirement? And how can we differ substantial merit to national importance?
I mean, to be honest with you, when it comes to both of those, they're very similar. So, but a lot of times I will have, the difference is that substantial merit is more general in scope and your national importance of your specific proposed endeavor is more narrow in scope. So I have had a lot of RFEs and I've seen denials where they come back and say, yes, we agree that your profession, what you're doing, it generally speaking has substantial merit. Being a doctor always has substantial merit. But your specific proposed endeavor of only working with Botox, we don't feel like is nationally important. I don't know if that makes sense, but that's how I would kind of describe it, in them saying, okay, yes, there is substantial merit in just coming to the U.S. and being in your field of professional as a doctor. However, Your specific proposed endeavor in only working on Botox, we don't feel like that's nationally important.
Okay. Okay, thank you, Carmen, for that. Israel Science mentions that the NIW processing lately takes many months. You were previously mentioned that it can be from 4 to 24 months, so you always usually talk about a year or more. And it has been getting longer, as Israel states. How has this affected your ability to sustain business from this case type?
I mean, to be honest with you, like I said, I just got an approval that was filed within a 4-month period, but we've gotten several in 2022 that were approved in 6 months or under. But we have several older cases. Like I said, we're just now getting decisions on a lot of cases we filed back in 2019 before the regression. So what your client can do right now is go to the I-907 and see if they qualify already to upgrade to premium processing if they're in a rush. We recently had an EB2-NIW case do that against our advice, because generally speaking, when you upgrade to premium processing, you're likely to right away get an RFE. And that's exactly what happened. So you just want to set your expectations to your client and say, okay, if you really are desperate to have this decision and you've been pending and you can now qualify for premium processing based on your priority date of your EB2 filing, do you want to file the I-907? If you do, you have to pay the government $2,500. You need to pay your attorney, and then you're most likely going to get an RFE, which is going to be more attorney's fees. But by all means, if you want to do that, you can do that. So nowadays, because of premium processing for EB2s, if you have that client that tells you, listen, I don't want to wait 24 months. Okay, well, you have the chance to upgrade as soon as you hit a certain point. It was in the beginning when they first allowed EB2-NIW this summer. The case had already had to be pending since March of 2021. Now I believe they've updated it, and you can check, I believe it's February 2022, and you can then upgrade to premium processing.
Okay. And Carmen, this question is more for me. We've talked about RFEs, and when it's expedited, you have a lot of RFEs coming basically almost automatically. What percentage, ballpark, would you get an RFE on an EB2-NIW application if it's expedited, and if it's not? What would be the percentage of applications that come back with an RFE?
I would say you're more likely than not to get an RFE. Now, a recent trend we've seen in the past year and a half is that filing the EB2-NIW consular processing, we seem to get less RFEs then. It's not a big difference. It's a small difference. And so we talk to clients there, and I will say this, if you do get an RFE and you've done it consular processing, your client's outside of the US, it can be difficult at that point to prove the well positioning to fulfill the proposed endeavor. But I would say, I would use the same immigration, burden of proof of it's more likely than not to get an RFE.
Okay. Perfect. Going back a little bit to the strategy, the immigration strategy, if it's not a business owner, then how would you prove the proposed endeavor without an employer or being a business owner? Rose Emir asked this question.
Right. So if the client, like I said before, if their experience has always been working with multinationals, then I would say, okay, can you get any letters of interest? Do you have any colleagues that are in the US that are working in this area and can back up that your degree in biomedicine is in high demand, and that there is definitely an interest in it? These or some clients have already received a lot of interest via LinkedIn and via other platforms, and I'm like, print that and give it to me. Give me all the interest that you can prove that you're currently receiving from US companies that need you. And so when we look at the client's resume and we see that this client has no background, they're not an entrepreneur, whether they work for, I always ask right away, have you worked for multinationals? What's your plan? And so then we try to look at that and say, okay, how can I prove this? Is it going to be through possibly letters of interest? Do we have headhunters that are looking for them? Can we get something in writing from the headhunters or from LinkedIn responses? A lot of our clients have been recruited abroad, and then they get emails from the HR department saying, wow, you're the perfect candidate. Unfortunately, we have a policy against sponsorship or something like that. So we compile all of that evidence and prove, or we can show vacancies, a lot of high demand for positions in that area.
Sergio Atanaso asked this question: why do EB2 exceptional ability in business rather than EB1A extraordinary ability in business?
Well, the EB1A threshold is just higher. I mean, you have to prove that you're in the very, very top tiny percentage of your field. And I'll give you an example. We had a Brazilian businessman, very successful, had invested a lot of money here in the US. And he wanted he needed a green card for his, actually, to be able to continue what he was doing with his business. He really needed to have permanent residency for some contracts and things he was trying to get. I told him, after looking at his resume, I thought he was more inclined towards EB2-NIW. He insisted on doing the EB1A extraordinary ability and doing it premium processing. We did that. And granted, this person is employing around 40 American workers at that time and has invested millions of dollars. And so we do the EB1A, get a horrible RFE. They don't give him a single point, which is ridiculous. We get a denial. We appeal the EB1A, turn around, file the EB2, straight approval, and in less than 6 months. And I told him, I said, you know what? I had told you from the beginning, this was the better route for your case. And so I would say extraordinary ability is always a completely subjective. So if your client has a business degree, especially, and they're an entrepreneur, then I would go the EB2 route all the way.
Okay, wonderful. We have a question here related to the business plan, but I'll ask you this one. It's from Nina Mohammadi. Should the attorney prepare the business plan?
Never. No, I mean, I didn't study business. I definitely, and it's just so time consuming. And I'm like, it's not our specialty. And it's just, I feel like, you know, when I talk to a client, I'm like, listen, there should be 4 people involved in your business plan. You, with your business background, your accountant a lot of times needs to be involved, your business plan provider, Joorney, and your attorney. And we all need to work together, and we all need to use our strengths to really have, you know, a good, well-formatted, concise business plan. And I will give you an example. I just sent to Joorney where we're trying to rescue a different type of case in E2. And the business plan, I mean, it literally states in it that the client is going to be operating out of his home residence in the beginning. I'm like, no, what attorney? And the attorney had done it. And I'm just like that. You're already setting your client up for failure. And so, no, I would say don't waste your time. That's unless you also have a business degree and that really is your passion, your specialty, give it to the experts. And you are there to guide and to supervise it.
Mm-hmm. We have a question from Carrie Fonte. Thank you, Carrie. Thank you for doing this presentation, she says. She asks, how involved do you get as an attorney in developing what the client will do in the US? So many clients have trouble expressing how they will continue to work in their field.
Okay, so first of all, Carrie knows I love her, and she was my first boss when I came to the US, to Miami. Sorry, I'm from the US. But she was my first boss, and it was pretty interesting, actually. Carrie and I worked on a case together where the client had done an L1 and then heard about EB2, and I was like, yes, she's my mentor. She's an amazing attorney, and you do, I believe, qualify for EB2. And he did win both, his L and his EB2. So how involved do we get? In the beginning, it's really important to make sure your client understands that by putting all of this into their plan, it's serious. It's not when they come to you and they say, well, you tell me, do whatever's better. No, you, client, have to tell me, what is it you really plan to do? And if you don't plan to work using your degree or your expertise, then I can't represent you. And so we've had several, I'll just say, Venezuelan clients who are very high level engineers, but they're currently working because they have an EAD, let's say through TPS or something else. They're working in a completely different area. Then I explained to them, no, you don't qualify right now. You get a job working in your engineering field and then come back and see me. And so as far as involved in actually helping them develop their business, no, but very involved in helping them decide and be able to define what they're going to do. Yes, from the beginning. Like, listen, you have these 3 options. You tell me, but if you're not going to work and you don't have a plan to work in the future in your area, you don't have a case.
Mm-hmm. Mm-hmm. Thank you, Carmen. Maria Fernanda Melgarejo, she's one of our very loyal partners. She asked, have you seen approvals of entrepreneurs where the business plan has not been implemented yet? Meaning that it's still just a plan.
Oh, well, yes. And that was actually the recent case I kind of mentioned where the wife had done the EB2 with a different firm. She was an attorney. It was a mess. Her EB2 got denied. We did his EB2 as an entrepreneur. He has an extremely successful company in Brazil. Now, his company in the US was just, I would say, launching. And he really explained what happened during COVID. And he was able to very clearly and very professionally explain the years it takes to get to where he is in Brazil, here in the US. And it made sense and we won. But do I recommend that? Absolutely not. It's like with an E2. You really want to do as much as you can at the time you're filing. So we tell our clients that are entrepreneurs, we want and require really 3 things before we file the EB2 if you're an entrepreneur. And that is a business plan, a commercial address, and a website. Those are basics. They're not really super expensive. I'm not saying you have to rent a huge office space, but at least a virtual office, a WeWork, something that's a commercial address, because that comes back a lot at the RFE stage.
Mm-hmm. Okay, so it's 12:15, Carmen. I know you're extremely busy because you have a lot of EB2-NIWs on your desk along with other things. So I really thank you for going a few minutes above. There are still some questions that people are asking. Of course, you can reach out to Carmen. Our marketing team is going to provide the email, and you can reach out to Carmen. If you're an applicant, of course, you can ask for her services. And if you're a lawyer, you can also reach out to her. Dra and Rach, can we add the email for Carmen and the website on the everyone chat? And Carmen, if you want to comment on that.
Yeah, I just want to say a couple of things. First of all, there's nothing to be scared of. If you haven't practiced or you've never filed an EB2-NIW, you're a lawyer, you can do it. If you can do an EB1-A, you can do an EB2-NIW. And also when it comes to emails, my turnaround time is not fast. It will take me a few days to get back to you at least. And I'm not here to do the EB2 for you, but I really believe in sharing knowledge and in helping you to help your clients. And so that's what I want you to do. At the same time, if you don't feel like you don't feel comfortable enough to handle an EB2, by all means, you can send it our way and we'll gladly handle it for you. But thank you, Joorney. Thank you to everyone who attended, and I'll be in contact. You'll have all my information.
Wonderful, Carmen. Thank you so much for accepting our invitation. And I hope that I see everyone and we see everyone on future webinars that we do. Thanks again, Carmen.
Thanks.
Bye,
Bye-bye.
everybody. Thank you for participating in our webinar, and see you next time. Bye.